Germantown Community Television, your hometown news and information station.
Welcome back. With us now is Artie Bird of the Jones Law Firm. We're talking about Chapter 13 bankruptcy. So we went over the nuts and bolts first, and then we went through sort of how the process would work, and we got into the situation of what happens if you get a substantial increase in income with your payment plan, and then what would happen if there's a substantial decrease in getting those changed. I guess one question that I've had come through my office, I didn't know the answer to, was, well, can I convert my 13 to a 7 if I've lost everything?
Absolutely. That's an option if you, again, we go back to the means test. And if now you're in the middle of your Chapter 13 and your income has decreased and you qualify under this means test, you can convert to a Chapter 7, and you can, in 4 to 6 months, discharge your unsecured debts and medical bills and all that kind of stuff. Now, the little caveat with that one is it depends on why you filed Chapter 13 in the first place. If you only filed Chapter 13 because you were above that means test, then sure, it's a good solution. If you filed Chapter 13 because you wanted to save your house and you're $20,000 behind and we're still catching up on the arrears, that's not a good solution in that case. But yes, you can convert to a Chapter 7 if the economy hits everybody. And if that happens, you can convert.
So now with a 13, because there's always the side of the debtor and then the side of the creditor.
Right.
And one of the ones where I see this most times is when we've got somebody that's renting property, they're getting close to an eviction, so then they'll go in, and the day they're supposed to be evicted in court, they've filed a 13 to stop that eviction.
Right.
How does all that work from both sides?
And in the scenario you just spoke of, that last part was important. If the landlord has gotten his judgment already, then it's a non-issue. The landlord has it, and you can't stop it after that. But let's say he hasn't gotten his judgment yet, and he's telling you he's about to evict you tomorrow, and we file our bankruptcy. If you're behind on your rent, which would probably be the case in that scenario, you can still catch up on the rent. You can basically put your rent arrears into the bankruptcy. It'll be given a pretty high priority. There's not a whole lot of assurances from the landlord's side, from the creditor's side, that he's going to get paid, and he wants to, and he should. The landlord can actually ask that he's paid immediately. Now it's going to be up to the court to determine, is that feasible? Can we really pay you this 3 months of back rent right now? If not, they ask for it promptly, and again, that's where we give that back rent the high priority. Now the renter is going to have to keep paying the ongoing payments as we go, and he can make up for the arrears and carry out the lease term. And again, in these schedules, when you're filing for bankruptcy, you say whether you're going to assume the lease or reject the lease, and you have that option. Now, if you assume it, you're going to have to keep paying the ongoing, and you'll catch up on the back rent fairly quickly.
Yeah, and if you don't pay the ongoing, then you'll get a motion to lift the stay.
Absolutely.
So the landlord can proceed with that eviction.
He can, and that will happen quickly. These creditors, landlords, mortgage companies, everybody else, if they're not getting paid, if the debtor's not following through with the plan that they laid out, they can lift the stay and they can take back their collateral, their space, whatever the case may be.
Okay. And the other big issue that I always run into with the bankruptcy is where there's a bankruptcy filing, and it's a joint filing by a married couple, and then the couple's getting divorced.
Sure.
Can their 13 be divided into two separate 13s?
It can be. You've got options on it, really. Now, again, let's go back to that scenario where both husband and wife are making the same amount of money, and each of them are paying half of the payment plans to the court. Well, as you know, in divorce, what we're doing is we're dividing assets and we're dividing debt. You can continue on together in your bankruptcy. You can leave it as a joint bankruptcy, and that can be dealt with in your marital dissolution agreement or whatever the case may be. Now, if husband or wife decides, I don't want to pay for his car, I don't want to pay for his credit card, I don't want to do all that, you can file a motion with the bankruptcy court to bifurcate the bankruptcy, to split it up. And each can go forward on their own, and they'll still have, obviously the plans are going to have to be modified, and what you're paying is going to have to be modified, but you can split it.
Okay. Yeah, that's the one thing that it's getting the two parts of the bar, the bankruptcy bar and the divorce bar, on the same page, right, which your office does both of those. So
we do, and I've recently had a divorce client who is in the middle of a bankruptcy right now. And to be honest, it was fairly easy to settle, and that may be because we've already got the debt sitting here. You've taken a big piece out of what we have to argue about in divorce. But we were fortunate there.
Okay, very good. Our time is up for this edition of Legalese. I'd like to thank our guest for taking time out of his busy schedule to be with us and sharing his thoughts and insights. If you would like more information about Legalese or any other program on GHS TV, please refer to our website at www.ghstv.org, where we're also streaming live 24 hours a day. You can also keep up with GHS TV by visiting us on Facebook and Twitter. Thank you for joining us today, and be sure to join us next month for more discussion on legal topics. Until then, I'm Vince Perryman, and thank you for watching.